Recording in progress.
Good morning, honorable members and colleagues. Can we start, Masi?
Yes, Chair.
Thank you very much. Can you then flight the agenda of today's meeting?
Can you see, Chair?
Yes, thank you very much, Masi. And once more, good morning, honorable members. I have seen also the DG is here and the team, and also the Parliamentary Legal Services team is also here, and all colleagues, good morning once more. This is the agenda of today's meeting. You are all welcome, honorable members and colleagues, to this meeting of proceeding with the process of the two bills, the PAMA and the PSA. We have meetings the previous weeks, and here we are even today. We're still proceeding with these two bills. But however, you are all welcome, and feel free to raise issues and also comment. And also, if you want to ask questions, ask questions. but so that at the end we produce the best report to Parliament. But however, I will also move to the next item of apologies. I think between myself and Masi, the only apology is the one of Honorable Komane, whom she wrote an SMS to Masi and indicate that she has a bereavement at home. The husband has passed away, and I will wish that all members send messages to of condolences to Honorable Komane. That's the only apology that we have, honorable members. And also, in our midst here, I must also, importantly welcome Honorable Mkhwink, who I don't see her on the platform. Honorable Ntuli, there's a new member, honorable members, by the name of
Honorable Ntuli logged in. Am I
No.
not?
You didn't hear me, Honorable Ntuli. I'm talking about the new member of the portfolio committee. I'm saying I thought she's here. I can see she's not here, Honorable Mkhwink. I was welcoming and introducing Honorable Mkhwink, who have joined this portfolio committee from the ANC. Apologies, comrades. I think I have dealt with them. We are then moving to the next item. I know that the team have sent to all of us the A-list, a document that we call A-list of the two of the bills, so that we familiarize ourselves with those A-list. That are the list that we must then discuss as this committee and then adopt, because they will be then after this exercise.
Sorry, Chair. Sorry. Can the host assist Honorable Mkhwink? He's trying to log in and he's got some problems. I'm sorry, Chairperson, with due respect.
Okay, thank you very much, Honorable Ntuli, and good morning also the Deputy Ministers here. So this document is not really a bill now. It's an A-list that must be adopted by this committee, and then it will be featured after as a bill that will be then that time of then adopting it, so that we then go and present it in Parliament. So, honorable members, I will also give the legal services so that we have an outstanding issues of the last meeting of the 4 clauses. There was clause 6, there was clause 8, there was clause 9, there was clause 14, especially in clause 14, the section 17A and 17B. So, Mr. Mwepe and Mr. Biela will then guide us of how the team will speak on the 3 clauses, because we have agreed in all the other clauses, but there were outstanding issues, because you have said to the committee the team will go and rephrase the 4 clauses, which is that I have just mentioned. But also the PSA is here. You are all welcome, colleagues. Especially those that I didn't mention, because I've seen also the PSA is here, the NSG is here. But however, I will then hand over to the team to take us through. But before we discuss the A-list, the team must talk to the clauses that we then agreed as this portfolio committee, that you're going to go and rephrase them, come and present them, discuss them before we move to the A-list. And thank you very much, Masi and Mr. Mwepe and Mr. Biela. Can you guide us? Thank you.
Good morning, Chairperson. Good morning, honorable members, and morning to honorable ministers and DG and the colleagues from the department. Chair, I believe that the Parliamentary Legal Service, they had thorough consultation with the state law advisors and the department with regards to what the committee have recommended the amendments on certain clauses, like as you have mentioned, Chair, both the amendment on the Public Service Amendment Bill and the Public Administration Management Bill. And everything, it has been well captured, Honorable Chair, but I think it's allow them to present the amendments, and then we'll then take it from there. But from our side, we have looked at those amendments from our side. We don't want to say we are happy or whatever. It's up to the committee to decide. We are not the members. Chair. Thanks.
Just before I give to Ms. Naidu, can Honorable Mkhweng open your, Mr. Gabriel Mkhweng, open your video so that you greet the member of the committee and also colleagues. And I have introduced you as the new member of this portfolio committee. Honorable Gabriel Mkhweng. Honorable Mkhweng. Honorable Mkhweng. Okay, Ms. Naidu, can you, the floor is yours.
Hello?
Yes,
Hello?
yes, I've introduced you as a new member of this committee. Can you just open your video and greet members of the portfolio committee, including the colleagues in this platform? Ms. Naidu, can you go ahead and take the floor is yours?
Thank you, Madam Chair. Good morning to the chair, members of the committee, minister, deputy minister, and DGs and colleagues. Chair, I perhaps want to just give confirmation that as a department, we have engaged with our stakeholders in terms of labor and our social partners. There is consensus on the amendments that are going to be proposed by the legal officers of Parliament. There is agreement that the amendments that are being presented to the committee will address the concerns that have been raised through the parliamentary comment processes. Thank you, Chair.
Yes, Ms. Naidu, can you then go clause by clause on the 4 clauses that were spoken about so that we must understand what has been rephrased by yourselves?
Chairperson.
Okay.
Chair.
Yes, Mr. Webb.
Yeah, I think the parliamentary legal services, I don't know the arrangement between the department and the parliamentary legal services, but I believe that the changes were supposed to come from the parliamentary legal service, not the department, because now the bill is before us.
And where are they now, Mr. Webb?
Morning, Chairperson. Morning, Chairperson. It's Talana Halley from Parliamentary Legal Services.
Yes, Mr.
Yes, so myself and the State Law Advisor had met regarding the Public Administration Amendment Bill, and following the consultations by the department with the relevant stakeholders, and following the consultations with the NSG, we developed the A list, which I will flight with your permission, Chairperson. And then I believe that the State Law Advisor, CISA, is in this meeting, and he will take us through the A list if that is in order with you, Chairperson.
Go ahead, Mr. Telan.
Sure. Okay, Chairperson, is Mr. Makabeni, should I do it, or do you want Mr. Makabeni to go through the A list? I'll take your lead, Chairperson. Would you prefer for Parliamentary Legal Services to take you through the A list? Okay, so Chairperson, as you know, these are the proposed amendments for the Public Administration Amendment Bill. The first amendment would be clause 5 to the bill. On page 5 of the bill, in line 4, after the term profit, we will then insert "and which are necessary for the functioning of an organ of state," full stop. This was an amendment proposed by the department. At clause 6, Chairperson and committee members, you will recall that we had illustrated that we could reword item clause 8 or section 8A of the bill. So on page 5, from line 9 of the bill, to omit section 8A and substitute it with the following section: conduct of the employee or former employee participating in award of work to service providers. 8A1, in this section, A, 12 months means a period of 12 calendar months following the conclusion of a contract with the service provider, and B, service provider means a person who provides services or goods to an institution against remuneration exceeding a prescribed amount. 2, an employee who, in respect of the award of a contract to the service provider, set a criteria for the award, evaluated or adjudicated the award, recommended or approved the award, or participated in any activity contemplated in paragraph A to C, may not, within the 12-month period, provide for any service to, accept employment with, or accept employment to a board of that service provider for payment in money or in kind, or receive any other gratification from that service provider, full stop. 3, a service provider may not, A, within the 12-month period, engage an employee contemplated in subsection 2 to provide any service to the service provider, or employ the employee or appoint the employee to a board of the service provider for payment in money or any kind, or grant any gratification to the employee, full stop. 4, subsections 2 and 3 apply irrespective of whether the employment of the employee contemplated therein continued or did not continue with the relevant institution during the 12-month period or part thereof. 5, the executive authority may, in accordance with the prescribed criteria, approve a period shorter than 12-month period contemplated in subsection 2 or 3. 6, subsections 2 and 3 apply with the necessary changes to any extension of a contract with the service provider if the remuneration for that extension, together with the remuneration for the original contract and any other extensions, exceeds the amount prescribed by the minister in terms of the subsection 1. Full stop. 7, any person who contravenes subsections 2 or 3 is guilty of an offence on conviction liable to a fine not exceeding 1 million rand. 8, the minister responsible for the administration of justice may, from time to time, by notice in the Gazette, increase the amount referred to in subsection 7. Honourable members, this was then the reworded section relating to clause 6, and myself and the state law advisor are of the opinion that the rewording creates a more concise understanding of what the intention is of the section. Clause 9. On page 6, in line 9, committee members, allow me to just explain that this was the sections that was reworded and proposed by the NSG. Clause 9, on page 6 of the bill, in line 9, to omit amendment and to substitute substitution. On page 6 of the bill, from line 33 in the bill, to omit paragraph E and to substitute the following for the following paragraphs. E, may conduct assessments or cause assessments to be conducted in respect of education and training programs or courses. On page 6 of the bill, from line 35, to omit paragraph F and to substitute for the following paragraphs. F, may, subject to the National Qualifications Framework Act, 2008, bracket Act number 67 of 2008, close bracket, award qualifications or post-qualifications on the successful completion of education and training programs or cause such qualifications or part qualifications to be awarded. And G, may issue certificates of attendance, proficiency, or other recognition on the successful completion of education and training programs or courses or cause such certificates to be issued, full stop. Finally, Chairperson and committee members, clause 14 was where we found the contentious issues regarding 17A and 17B of the bill. And following consultation with the relevant stakeholders and suggested rewording by the department, myself and the state law advisor sat with the suggested changes and proposed as follows. On page 7 of the bill, from line 11, to omit section 17A and to substitute the following section. Removal of disparities in public administration, 17A. In order to remove unjustifiable disparities in relation to remuneration and conditions of service for employees who do not fall within the scope of a relevant bargaining council, the minister may, subject to applicable labour legislation and legislation governing the employment of employees in the public administration, and after consultation with the relevant minister, prescribe A, norms and standards to establish the upper limits of remuneration and conditions of service, and B, steps to remove unjustifiable disparities in remuneration and conditions of service, provided that these steps may not reduce any employee's remuneration, full stop. On page 7 of the bill, from line 25, to omit section 17B and to substitute the following section. Determination of conditions of service with financial implications. 17B. In this section, accounting authority in relation to a national or provincial public entity means the accounting authority contemplated in Section 49 of the Public Finance Management Act 1999, Act number 1 of 1999. B. Accounting officer in relation to a municipal entity referred to in paragraph B of the definitions of public entity means the official of the entity referred to in Section 93 of the Local Government Municipal Finance Management Act 2003, Act number 56 of 2003. Conditions of service includes annual salary adjustments, salary scales or levels, performance bonuses, pay incentives, pension benefits, and any other such benefits. And D, executive authority in relation to a public entity referred in paragraph A of the definition of public entity means the minister who is accountable to Parliament for a national public entity or in whose portfolio it falls, or the member of the Provincial Executive Council who is accountable to the provincial legislature for the provincial public entity or in whose portfolio it falls. 2, there must be a committee of ministers consisting of the ministers responsible for finance, education, defense, police, correctional services, and such other ministers as the cabinet may designate, and must function the same as a committee of the cabinet. 3, subject to the Labour Relations Act, the laws governing the employment of employees, and any collective agreement. A, no executive authority in the public service may enter into a collective agreement in respect of conditions of service with financial implications or determine them for their employees without a mandate from the Committee of Ministers. B, no executive authority, municipality, accounting authority, or accounting officer in respect of a public entity may enter into any collective agreement in respect of conditions of service with financial implications or determine them for that public entity's employees without first consulting with the minister and the Minister of Finance. Or the minister responsible for local government and organized local government in respect of a municipality may not enter into any collective agreement in respect of conditions of service with financial implications or determine them for municipal employees without first consulting with the minister and the Minister of Finance. And 4, the Committee of Ministers must establish an intergovernmental forum in terms of Section 9(1) of the Intergovernmental Forum Relations Framework Act 2005, Act number 13 of 2005, including premiers, deputy ministers, and any other member that the committee may determine to consult for the purposes of subsection 3. And 5, the Committee of Ministers in determining the mandate contemplated in subsection 3 and any other employer in the public administration prior to concluding a collective agreement or determining conditions of service for their employees must take into account affordability and any other factor prescribed by the minister in consultation with the ministers of finance, full stop. Clause 16 on page 8 of the bill from line 39 to omit 3B and substitute it for 2. And this is an amendment because of the change in clause 14, the reference then to ministers or Committee of Ministers would then be 3B as opposed to 3B, it will now be 2. So, Chairperson, these are all the changes. Just to point out again, as you can see from 17A and B, we have now ended ended the first 17A without providing that the steps may not reduce any employee's remuneration, full stop. We've deleted a phrase there. And then also in 17B, we've added these definitions to make it clear that there is a difference between the public service and that of the public entities and municipalities. Where it comes to public entities in the province and in national, they will just merely consult with the minister and the Minister of Finance, whereas the executive authority in the public service will have to have a mandate before entering into conditions of service. And that is also to emphasize that this is also taking into regard collective agreements and the Labour Relations Act. I trust that this is sufficient, and I would like to hand over to you, Chairperson. Thank you.
No, thank you very much, Ms. Delane. Honorable members, we have started with the A-list of PAMA, the Public Administration Amendment Bill, and that has touched the clauses where we had issues, and I will then give, like what we did last week, honorable members to speak on the clauses. I know that there's clause 5, there's clause 6, 9, 14, and 16 in the list. So I will give honorable members to speak on the A list of PAMA. I'm taking hands, honorable members. At least now these clauses have been rephrased. Are you then comfortable on how the Legal Services of Parliament have rephrased these clauses as per the concerns and comments of last week's meeting? So I'm taking hands, honorable members.
Yes, Honorable Chairperson.
Yes, Honorable Nduli and Honorable Gibi.
Thank you, Honorable Chairperson. Greetings to the meeting, particularly the DM in our midst. Chair, I think on our side, one is happy with the A list and the rephrasing. The emphasis on the Committee of Ministers and consultation, and also acting on mandate, to me, Chair, is profound. It does really give the background insofar. Without much ado, Chairperson, I fully agree with the presentation. Thank you, Chair.
Thank you very much, Whip, Honorable Nduli. Honorable Gibi.
Thank you, Honorable Chair. Good morning to your good selves, to the Deputy Minister, the Honorable members, and the colleagues on the floor. Honorable Chair, let me also join Honorable Nduli in welcoming the presentation. One really feels comfortable, Honorable Chair, especially that all the rewording that we were concerned about in our last meeting, and so also the suggested changes have been made, and also to hear that the unions have also been contacted and they are comfortable with the changes and all of that. I also support what Honorable Nduli said. I thank you, Honorable Chair.
So then, thank you very much, Honorable Kibi. I think on the PAMA, it's agreed upon, then it will be then included with all the other clauses, and the team will bring it in the next meeting. We are then, if there's no other hands from honorable members, moving to the next A list of PSA. I don't want now to call Ms. Knight because I can't differentiate between Ms. Knight and Ms. Delane. I will call Ms. Delane now to deal with the next A list of PSA. Ms. Delane.
Chairperson, Miss Gangan is in the committee, and she's going to take the committee through the PSC.
Good morning, Chairperson.
Yes, Ms. Daniel.
I'll be taking the committee through the A-list, the proposed A-list with the amendments. Before I start, let me just greet everybody on the platform. So good morning to all on the platform this morning. Chairperson, you will recall that at our last meeting, there was a concern about the amendment bill as it now reads, insofar as the amendment bill allowed for the unilateral determination by a state department for the recovery of overpayments of monies. And the state law advisor, together with the department and myself, have really tried to rework the clause so that it is constitutionally compliant and it's fair insofar as recovery of monies by the state is concerned, fair to the state and also fair to employees. Chairperson, with your permission, if I may just switch off my video so that I could share my screen with the A-list.
Yeah, no, that's fine.
Is my A-list visible to the committee, Chairperson?
Yes, Mr. Lushin.
Thank you, Chair. So just to reiterate, the difficulty that we were faced with the amendment bill as it now stands is that failing consent, it allowed the accounting officer to still be the judge and jury in its own cause, which was in violation of Section 1C of the Constitution. And what the state law advisor, together with my colleagues at the department, has done is that they've reworded the section in its entirety. So I'm just going to take the committee through the A-list. There were minor amendments to clause 2. So I'm just going to start at the beginning. Our A-list starts with the Republic of South Africa Portfolio Committee Amendments to the Public Service Amendment Bill B13 of 2023, as agreed by the Portfolio Committee on Public Service and Administration, B13 2023. Proposed amendments to the Public Service Amendment Bill B13 2023, and we move on to clause 2. So on clause 2, there were minor amendments in just stylistic and language. So number 1 on page 3, in line 49, to insert the words of the relevant department after the words executive authority. And number 2, on page 3, in line 55, to omit the word may and to substitute with the word must. Clause 18 was the contentious clause that I referred to earlier, and we've reworded the entire clause, and it now reads, number 1, on page 10 from line 38, to omit paragraph B and to substitute the following. B, been overpaid or received any such other benefit not due to him or her, Roman numeral 1, an accounting officer shall recover such overpayment by way of deduction from the employee's salary if the accounting officer and the employee agree in writing on A, the amount of the overpayment, B, a reasonable period for the repayment of the amount of the overpayment, and C, the amount to be deducted from the employee's salary either in full or in monthly installments, taking into consideration the employee's income and current financial obligations, provided that the total monthly deduction is not more than 1/4 of the employee's monthly salary. Roman numeral 2, an accounting officer shall, in the absence of an agreement contemplated in sub Roman numeral 1, recover such amount of overpayment by way of legal proceedings. Roman numeral 3, an accounting officer shall, in the event that the person is no longer in the employ of the department, recover such amount by way of deduction from any monies owing to such person by the state or by way of legal proceedings. Roman numeral 4, an accounting officer shall, in the event that that employee is in the employ of another department, request the accounting officer of that other department to recover in the manner contemplated in subparagraph Roman numeral 1, the overpayment made. Roman numeral 5, that other benefit shall be discontinued or withdrawn as from a current date, but the employee shall have the right to be compensated by the state for any patrimonial loss which he or she has suffered as a result of that discontinuation or withdrawal. Chair, that is the rewording of clause 18. The state law advisor and the department, together with myself, we are of the view that it adequately addresses the concerns that was raised in the committee meeting and that was raised by the Constitutional Court regarding recoveries of monies owed to the state. Before I would hand over to you, Chair, I would just like to thank our state law advisor and the department for the assistance with the redrafting of this clause and with the drafting of the A list. Thank you, Chairperson. I'll hand over to you.
No, thank you very much, ma'am. Honorable members, that's the A list from PA of the PSA. Can I then take hands from honorable members? I see one hand of Honorable Duli.
Thank you, Chair. I stand to agree with this A list, but with one exception, just for clarity, that in this regard, the role of the minister is absent. The role of the minister is not visible, but I'm not saying make it visible if it's unnecessary. But I wanted just a clarity, because for me, that one would be essential as well. But again, the mandate just the clarity, Chairperson, the mandate here for me is not clear on acting in terms of the employee that has moved to another department, and now the new, meaning the accounting officer of the department, of the new department, if I may say, is also required to continue with the deduction. If they may just clarify the mandate around that one. Yes, Chair. But otherwise, I stand to agree with the aid.
Honorable Kibi.
Thank you, Honorable Chair. Chair, I also want to agree with the presentation, especially on the issue of the overpayment, because that was something that was really not going well with the committee last time. Now I can see that it has been responded to, and yeah, Chair, that's it. Thank you, Chair.
Can the legal team respond to the question by Honorable Mtuli? I think that's the only question, colleagues.
Chair, if I may, I'd like to ask if my colleague, Ms. Naidu, could just answer this question, because at the last meeting, she had very clearly explained the definition section, which then clarified how it will work. So the executive authority in respect of the department is the minister and so forth. Renisha, are you able to just go through that again for the committee?
Thanks, Tuloshni. Chair, with your permission, Section 38, as I understood the question, relates to how the state will recover overpayments in salary, where there have been errors in capturing, and therefore that amounted to an overpayment which then needed to be recovered. There was a constitutional judgment. This is that provision that dealt with that constitutional judgment that set aside Section 38. It said that the state cannot unilaterally deduct from an employee's salary without parameters being set. As we drafted this provision, we had to then correct that particular section. So there is no role for the Minister for Public Service and Administration to play in this particular section. It's about how an accounting officer and an executive authority within this framework deal with this particular recovery. So the provision is written, and you won't see a reference to the Minister for Public Service and Administration because of that lack of a role that needs to be played. What this provision did, as we corrected it, initially, when we had started this process, we had, and this was the discussion at the last committee or the previous committee's meetings, where we explained that we had initially sought to put parameters under which deductions could be made without the consent of an employee. When the bill was submitted to Parliament, we had provided a bill that says, if the state wants to deduct monies from the employee's salary, then the state needs either the consent of the employee or they must institute legal proceedings, that's court proceedings. During the discussions, there were comments from the public participation process where Kasatu had raised concern that in the bill that was at NEDLAC, there was provision for unilateral deduction with certain criteria in place. We have gone back, and the view of the legal experts in Parliament as well as the state law advisors indicate that there are no circumstances under which the state can unilaterally deduct monies. So the bill now reflects conditions where the employee consents, but that deduction is still subject to certain parameters that have been set out now in this bill. So currently the provision is if there's overpayments, that accounting officer or that executive authority may deduct monies with consent of the employee. And if that consent is given, then the parameters where it can't exceed 25% of the salary, etc., are built into the law. If there's no consent, then it will be through legal proceedings. There's also a provision that if the employee moves to another department, that other department, which is department number B, can then be requested to then consult with that employee to make those deductions. But again, it requires the necessary consent for that employee, for that department B to make any sort of deductions in respect of that overpayment. So that's how, Chair, the provisions of Section 38 are now being revised through this bill. Thank you very much.
No, thank you very much. Is there any further issues, honorable members? Oh, which means they are all okay. I think those are the two presentations, and maybe I want to also give, if maybe the DM, because it's in the platform, or the DG, they want to say something, so that I release the department and also the team of legal services, so that Tina will proceed with the minutes of the previous meetings. Do you want to say something, DG, and then I'll give the DM? DG? DG? Okay. DM? Okay. Thank you very much to all of you, colleagues. I think we are done with the two A-list, and Mr. Ngwepe. Is it the understanding?
Correct, Chair.
Yes, so thank you very much to all of you. I think that's the end of our first item. And if you want to leave this meeting, you can do that. We'll remain as honorable members so that we deal with other issues, which is the minutes of the previous meetings. And thank you very much.
Thank you, Chair.
Thank you, Chair. Bye.
Can I proceed, Chair?
Yes, proceed, Mas.
Thank you, Chair. Morning to you, Chair, to honorable members and colleagues. We have 5 sets of minutes, Chair. They're very short chapters in their nature. So I'll try to move as quick as possible, Chair. These are the minutes of the 13th of September. 13th of September 2023, Chair. I'm on page 1. I think this day we're being briefed on the bills in terms of the analysis, Chair. Page 2. Page 3. Those are the minutes of the 13th of September, Chair.
Honorable members, the minutes of the 13th September 2021, when the team were giving us the summary analysis of the submissions by organizations and individuals. And obvious, the content of the meetings, it's what we discussed in the presentation. If there are other issues, comrade, that you think that honorable members that have been left, can I then take hands if there are additions or comments to the minutes, especially the content? Honorable Notnachal, Honorable Maneli, and then followed by Honorable Kibi.
Thank you, Chair, and good morning to everybody on the platform. I move for adoption of the minutes. Thank you.
Minutes adopted by Honorable Notnachal. Any seconder?
Chairperson, I second.
Very much, Honorable Maneli. The minutes of the 13th September 2023 adopted and seconded by the Portfolio Committee.
Thank you, Chair. I'm on the minutes of the 20th September 2023. PSA, PSC, and we also met CETA. I'm on page 1, Chair. Page 2. Page 3. Page 4, Chair. Those are the minutes of the 20th September, Chair. Thank you.
Thank you very much, Masi. Honorable members, the minutes of the 20th September 2023, there was a presentation from the CPSI and the PSC and also the CETA. And the content is there. And I will request that if there are additions to the minutes or any omissions, honorable members, I will take Honorable Kibi's hand is up, Honorable Ntuli, Honorable Notnachal.
Thank you, Honorable Chair. On the minutes of the 20th of September, Honorable Chair, this is the true reflection of the minute of the meeting that we had on the 20th. I therefore move for the adoption of the minutes of the 20th of September. Thank you, Chair.
Minutes of the 20th September 2023 adopted as the true reflection. Any second, honorable members?
Honorable Ntuli, I second Honorable Kibi on the adoption of the minutes of the 20th.
Thank you very much, Honorable Ntuli. The minutes of the 20th September 2023 adopted and seconded as the true reflection of what happened on the 20th September 2023. Any?
We move, Chair, as fast as possible. We are on the minutes of the 11th of October. That's when we received the briefings for the PRRR from both from departments, PSC and Auditor General. I'm on page 1, Chair. Page 2. Page 3 and page 4. You remember, Chair, that the discussion of these are always factored on the report, so we don't have information that is much on the minutes. These are the minutes of the 11th of October, 2023, Chair. Thank you.
Thank you very much, Masi. The minutes of the 11th October 2023, the AG's audit outcome, the BRRR of all of the department and also the entities. I will take hands. Honorable Ntuli's hand is up. Honorable Kibi.
Thank you, Chairperson. I move for the adoption of this set of minutes.
Thank you, Honorable Ntuli. The minutes of the 11th October adopted. Honorable Kibi.
Thank you, Chair. I support the adoption by Honorable Ntuli.
Thank you, Honorable Kibi. The minutes of the 11th October 2023 adopted and seconded as the true reflection of what happened on the 11th October 2023.
We're on the second last one, Chair, now. These are the minutes of the 17th. Basically, we were on the public hearings on this one, Chair. On page 1, we had members that were also online, Chair, and most members were also present in Parliament. On page 2, page 3, Chair. That's the last page, Chair. These are the minutes of the 17th October, Chair, 2023.
Thank you very much, Masi. The minutes of the 17th October 2023, which means the day one of the public hearings. And it has also been indicated that some have been captured, however, they were online and others were physically in Parliament. Any hands from honorable members on the minutes? Honorable Kibi, followed by Honorable Ntuli.
Thank you, Honorable Chair. I want to suggest that we adopt the minutes of the 17th of October as presented by Masi. I thank you, Chair.
Thank you very much, Honorable Kibi. Minutes has been adopted. Honorable Ntuli.
Thank you, Chairperson. I second Honorable Kibi.
Thank you very much, Honorable Ntuli. The minutes of the 17th October 2023 adopted and seconded as the true reflection of what happened on the day one of the public hearings. Thank you.
The last minutes for today, Chair, these are the minutes of the 18th October 2023, day 2. I've also noted Tamlu's comment on WhatsApp on slight addition on the amendment on the name of the minister. They have noted Tamlu. I'm on page 2. Page 3, Chair. We also adopted the BRRR on the day, Chair. That's the last page there. These are the minutes of the 18th October, Chair, 2023. Last set of the day. Thank you, Chair.
Thank you very much, Masi. The minutes of the 18th October 2023, the public hearings, day 2, we dealt with the oral submissions, and then also we adopted the minutes of the previous meetings. So, honorable members, I'm taking hands. Honorable Ntuli, followed by Honorable Maneli, and then followed by Honorable Ntuli, and then Honorable Kibi. Honorable Maneli.
Thank you, Chair. I move to to adopt the minutes as a true reflection of what transpired on the day. Thank you, Chair.
Thank you very much, Honorable Maneli. The minutes has been adopted. And second, Honorable Duli.
Thank you, Chairperson. I second Honorable Maneli.
Thank you very much, Honorable Duli. And the minutes of the 18th of October 2023, the day 2 of the public hearings, have been adopted as the true reflection of that day. Anything else, Amasi?
Yes, Chair. I think we are done for the day, Chair. But just to sneak in an announcement, Chair, to say now the committee, we've got about 2 weeks left, which is the week of the 22nd November and the 29th November. Chair, next week we are meeting with the PSC as per the program, and also there is a meeting with the DPSA. So those are the 2 agenda items of the 22nd. Now, what will then happen with this process of the bill, Chair, is that we will then process this amendment and then submit it as a B bill to the portfolio committee on the 29th, Chair, for adoption with the report of the committee, which will then be submitted to Parliament for further processing to the NSOP, Chair. Thank you so much, Chair.
No, thank you very much to you too, Amasi. Honorable members, we have heard that we will have the second meeting on the 29th that will then adopt the bills, as Masi said, B bills, which means, honorable members, while we still have to adopt these bills, go through all the documents if you picked up issues, so that on the day when we meet and we adopt these bills, if there are issues, we then look at those issues, rectify them if there are, and then adopt this bill. But however, thank you very much to all of you, honorable members. Thank you. I know it has been a difficult journey of having meetings Tuesday, Wednesdays, but here we are at the end of this process until that day when we are convened to adopt these 2 bills. Go through your notes, honorable members, and thank you very much to all of you, and thank you very much to the team of Parliament, the legal service of Parliament, I think led by Mr. Lani and others, and thank you very much to our support team that is always every time available to advise, guide, and sometimes call and say this is what we think that must happen. And thank you very much to all of you, honorable members. The time now, it's 10:35. And I will wish that also we convey our messages to Honorable Koman, who's always available for all meetings and also available to input in the presentations. But now, here she is, the husband has passed on, and I will request that in our portfolio committee group, just send your condolences messages, honorable members. But however, it's 10:36 and the meeting is officially adjourned, and thank you very much to all of you.
Thank you, Chair. Goodbye.
Thank you, Chair. Goodbye.
Bye-bye, Slalo and committee members. Thank you, ma'am. Thank you.